Good afternoon. Thank you. All right. So, what I suggest doing this afternoon is maybe splitting our time in 4 blocks. The first one is just giving the floor to Sandrine, Thomas, and Willie to hear back from the conversation that took place before lunch. Just some key points so that we're at par of what has been discussed in other groups and the richness of the brilliant ideas that emerged then. Second, we'll have a panel with more inputs from 3 distinguished guests. So then we'll be able to hear more and build on the conversation that has taken place along. Third, then we'll have an opportunity together in plenary to distill some key advocacy point that build on the sum of all the things that we've learned or that we've discussed today. What are the key things you think we should pitch? We should, if we have opportunities for advocating.
1, 2.
Could we distill as a group elements we would think would be interesting to advocate for, maybe at the national but also regional level, for changes when it comes to access to justice for children? So we'll have a bit of a discussion on this at the third point. And lastly, we'll ask our committee of wisdom with Théophane and Cornelius to give us some concluding remarks on what they've heard for the day. That's the plan. No one is leaving, so it's a sign that you're okay with that. So how should we start? Maybe Sandrine, would you like to take the floor? South Africa.
So yes, we were in the group of South Africa. Sorry, I'll now move on. We had lots of very interesting discussion, sharing practices, mostly from South Africa. And we came up with some recommendations or aspects that we think are important to improve access to justice for children. One of the aspects is linked to the multi-sectorial collaboration. And I cannot say that this is a new area, but we have discussed about the fact that all of the systems are working very much in silos, and that this is really impeding a holistic approach and a child-centered approach to access to justice. So there were some interesting recommendations, making sure that the different professionals understand and recognize each other's profession, constraints, and difficulties. So trying to make sure that in order to work better together, we understand the constraints and the area of responsibility of each organization, because if we understand each other's better, we can work better together. So there were recommendations about having more training at the initial level, the pre-service trainings, and maybe having some exchanges between universities of, having legal students spending some time with the social services and vice versa, to try to foster a better understanding and a recognition that everybody has a role to play and we need to be able to better work together. The second aspect, we debated a bit about what is justice for children, and justice is a concept that is much larger than the formal justice process. There were recommendations to say, well, if we really want to make justice for children, justice is about self-restoration of your power, feeling, like the well-being of the child, and the healing process is a major part of the justice process. So how can we, foster that throughout the different formal justice processes or others, making sure that we focus on the self-restoration of the rights and the well-being of the children. And one way maybe to make the child justice system more child-focused is clearly to listen to children. We know that even though there are elements and procedures that would allow for children to express their views when they are in the formal justice processes, in reality this doesn't happen very much. And the children are rarely engaged in giving their views and being part of the decisions about how to keep them safe and what would be the best option for them. We tried to unpack a little bit why this is, and there's a lot around skills and capacities of adults and professionals to collect the views of children, but there's also something probably a lot more difficult to change, which is the attitude of adultism that was mentioned, is how children are viewed almost de facto less competent than adults. And we don't have a solution to change that. I think it will take a lot of time and efforts. We also discussed a lot about the social service and all of the professionals, training and the support that they need, both in terms of capacities and attitudes, but also the duty of care for those professionals and how difficult it is to be dealing with cases of child abuse, and recognizing that they need a level of empathy and openness to be doing a good job, but that required that there is proper supervision in place. And when we say supervision, it's not making sure that things are being done, but really professional debriefing and assistance to make sure that professionals are open and supported to be able to do their job better. We've approached the issue of prevention by talking about offenders and say, well, how do we engage with to prevent offending? And it might be with working with offenders to prevent re-offending, but it's also probably to work with young people who are a big part of the ones who display harmful behaviors, and how do we engage with them in a preventative way to address it before we have to go through the justice process. And maybe the last aspect was around building in more accountability mechanisms. I mean, in law, there's a lot of provisions that are foreseen for people to be working together, to listen to children, and etc. In practice, we see that this is not systematically implemented, and so how can we build in more systematic accountability mechanisms to make sure that what is foreseen is actually implemented in practice and benefits the rights of children? And the last discussion I'd like to share is we had some discussions, no conclusion, about the different forms of justice and the formal criminal justice systems, the more traditional justice, and we understand that there are failures in both sides, and there's probably a way to explore what can be the different processes to render justice to children that would respect their rights and make sure that they come out with a strengthened well-being, and they feel that justice has been done for them, but they are not more victimized after the process than before.
Thank you, Sandrine. And thank you, Edith. You made the discussion quite lively and concrete, so that was really a brilliant discussion. Thank you. Let's continue. Maybe I think Willie and Joy's group was for Kenya, our host, and you'll be presenting the conclusions. Thank you.
From here? Good afternoon. So we met with Kenyan attendees and adopted some from several other countries, and we had recommendations that were given during our short meeting. And the first one was to institutionalize training within the learning institutions, for example, universities. So how this will work is for all these professionals who are working with children, for example, police, prosecutors, the judiciary, lawyers, they all go through a certain institute. And we thought it wise that we have a curriculum, or in their learning, in their usual learning, they have the basics of child protection taught within the institutions, so that as they come into the real world of working, they already have the requisite knowledge that is needed to ensure that they are the right practitioners that are needed to safeguard the rights of children. Then we had one of the challenges identified as frequent adjournments that was delaying justice. And the recommendation that was given towards this was to come up with a mechanism to monitor the service charters within the agencies that support children in the cause of justice, so as to just ensure that if the probation one says within 7 days a child needs to have been supported and referred, that is exactly done as so, because we already have the charters, but no one really goes into the monitoring bit of this. Still on adjournments of court matters that affect children who are survivors of SEC, a recommendation was given to go through the CCUCs. This is the Children Court Users Committees that are situated in all the in the courts, and use these CCUCs as a platform to report or to give feedback on cases that are delayed, as that process really triggers expedition of justice in these cases of survivors of SEC. A recommendation towards this again was given to have an electronic IT-based tracking system where the cases can be tracked, and also you can, at a glance, you can tell there's backlog, and even maybe deduce what's the cause of the backlog, if it's the cases that are too many, if it's the magistrate or the judge who's not maybe being supportive. So just engaging IT in the tracking of these cases. There was a recommendation for capacity building of police to be able to investigate, and even the medical doctors to be capacity built on how best to give their testimony in court when supporting victims and survivors of SEC. One of the challenges that had been identified through the Kenyan fact sheet was on compensation. A case is concluded, a case which is criminal, then every child, upon conclusion of their case, has a right to compensation, but this doesn't happen. So there was the issue of the victim trust fund, which has not been operationalized. Recommendations were given that we loop in the treasury in our meetings, in our lobbying efforts. We make sure that we have the treasury constituted in our lobbying efforts to forge forth with ensuring that this trust fund is operationalized. They'll literally give us the how. We know that the people we should have, but we know that we should be having a trust fund, but they're the people who will tell us how this can be actualized. And it's interesting to note that we've been talking about it, but we've never looked anyone from Treasury. About having a child-friendly environment, this was cited as a challenge up from the police station level down to the courts. It was one of the challenges that was highlighted, that the environment is not child-friendly. And a recommendation given towards this was to ensure that we have psychosocial support for children from the onset up to the conclusion, and even after, where we talk about probation and aftercare, to have psychosocial support of children before they enter the criminal justice system. This is maybe from the police station, all through the courts, to avoid the situation where we always come in with a psychologist when there is crisis, when the child can't talk in court. So it was recommended that we have psychosocial support all through the system. Then there's an interesting comment that creating safe spaces is not about the physical spaces. It's even through our attitudes, our conduct, how we do, what we say, all that contributes to creating safe spaces. One of the participants gave a good recommendation on having, adopting therapeutic jurisprudence and ensuring that we involve children's voices, and the experiences in the criminal justice, because they're the people who know where the shoe pinches. We should involve the experiences as we try to come up with solutions. This was also a recommendation that in as much as we're trying to embrace technology, talking about the Zoom links instead of going to court physically, the video recorded, sort of giving evidence in court, we need to be mindful of children who are survivors of OXA or abuse that was perpetrated through, was enabled through technology. So this could be a trigger. So when you're trying to use technology to enhance access to justice for children, be mindful, be thoughtful of those children who might have encountered abuse while using the same media. And the second last one was on the second last one was on access to justice for children in conflict zones. Means to access justice. And just like Sandrine's group, on this one we had no solution really, but we agreed it's something we really need to think about. Justice, access to justice for children in conflict zones. And the very last one was an effort to loop in the CSOs in service agency contracts, so that we have CSOs engaged by the government to offer services that are critical to the holistic support of children who are survivors of SEC. A good example was given of Namibia. It's working, and it's something that we'd like to explore in Kenya. So that was a quick summary of what the Kenyan team did. Thank you.
Brilliant. If that's the summary, imagine the conversation. So from what I saw, it was really rich. They were really zooming in on the procedure, the multi-sectoral collaboration, the hiccups, and the bottleneck in the procedures. So very rich conversation for Kenya. And now to conclude, not least, Anna, you're deferring to our colleague here for Uganda. So please, the floor is yours.
Good afternoon, everyone. So for Uganda, we had a different approach, and we had each country give some of the things that are working in their countries and the promising approaches. So some of the things that were working is compensation to victims should be after completion of the formal justice system, because there was a very heated discussion there with regards to the formal and informal justice system, the traditional and the traditional and the formal justice system. Because in Uganda, somebody said that they actually allow the court system would be going on, but the traditional justice courts would also, the traditional courts would also be sitting to try and mediate and probably find solutions and compensation. So people were not so okay with that. I know Rwanda, Kenya did not agree with that. Mozambique, Madagascar, Zimbabwe, because I think the issue is about how do you differentiate, like what happens to the victim? Like for Kenya, it was more of how do you differentiate when both the processes are going parallel, in terms of wouldn't there be witnesses who are going to be, how do you put it? I mean, these are the same witnesses who are going to come to court, but by the time they're already meeting with the perpetrators' families to try and discuss compensation, it's very easy for the formal justice system to be abandoned when that happens. So I think the solution we got from Zimbabwe was, how about let the formal justice system end, then come and go through the traditional where you can seek compensation, especially when there's a child who's supposed to be probably taken care of and maintenance is involved. I think the other thing was one-stop centers. This was a classic example in Madagascar, where they have a one-stop center in the hospital, and at the hospital is where the police come, the social workers come. So it helps, especially when it comes to re-victimization and re-traumatization of the child, because everyone gets the information at one place, so the child will not have to go to all these different places and give the same information again. We also had the township courts, especially in the high density communities, where the formal justice system, they go to the community and they speak to, they try and sort out the cases over there, especially in high density areas. When they realize that some of the cases come from a particular place, they go there to sort out the cases on the ground. Then we also had the government should fund victims through the court system, because most often than not we find that it is the NGOs that end up funding and helping the victims through the court system. So if the victim is abandoned, then that's it if the NGO doesn't have money. So the government should actually take up funding the victims through the whole court system. That means psychosocial support, transport, everything. Friends of families was very interesting. As in Rwanda, they have friends of families on the ground who follow up on cases, especially on violence against children. So they follow up and know what is the status of the case, how is all this going on, you know, they'll help find witnesses and everything. That was very interesting, because you find that most often than not, the families that have cases or that have a child who's been abused are usually just left on their own. But these people ensure that this child has gotten psychosocial support, is able to go to court, and will ensure that they finish the court process as well. Registration of children who have been defiled. Somebody said that the children who are born out of defilement, one of the solutions was to register them under the girl's father, so that they don't have the chance of not having a father or lacking registration in totality. Because most often than not, if I realize that in some countries, without the father, it's very hard to register the child, and the child will not have any documentation. Foster family care for victims. So as opposed to institutionalizing the victims, we get foster families to actually help care for the victims until the process of the formal court system is finished. Case conferencing, bring children together to be able to speak about cases that are ongoing, and also be able to maybe because when you bring all these children together, maybe some of them will realize that they've also been abused, and that's a way of them to be able to report some of the things that are going on with them. Case management teams, all duty bearers to meet and evaluate the court process and how the cases are going, and what were the chances of success in different cases, and why some cases end up maybe falling through the cracks. So case management teams, and just having all the duty bearers sit together and try and assess the pros and cons of all the cases that are going through the justice system. Child-centered processes, ensuring that everything that we do and every stage that we are taking the child through in the justice system should be actually child-centered. So it's the child at the core of it all. So even anything we do, we make sure we take care of the child. Then prosecutor-led investigations in Uganda especially have helped, because the prosecutors help the police in their investigations, and this has helped fast-track most of the cases, and has increased the success of the cases in the criminal justice system. So I think for us, the other question was, how do you link peer-to-peer reporting when it comes to access to justice? And the whole question about bringing in the formal justice system and the traditional justice system, how do you marry the two without having to infringe on the rights of the victims? So those are two questions that our group we need to answer, I think. Yeah.
Thank you. Very disappointed you didn't address them all. No, I'm thinking you did a brilliant job and summarizing a very packed conversation. And it's very interesting how Uganda can inspire a lot of practices. I mean, overall, it's quite impressive to think that when you get into the granular, there's so many small little things that have been piloted here and there that do build transformation in the system. The issue is maybe connecting the dots between all of them, but the vision of the experience that is already in the different systems that we have is really inspiring. And perhaps that's the bridge we can make to allow Theophanie Kiema to come forward and introduce our next panel, which I hope will make additional connections to the great ideas that emerge in those three working groups. Just want to take a moment again to thank the rapporteur and the key speakers in those three groups for their work, because I think it really was inspiring to just generate a lot of richness in the exchanges. So thank you to the 6 of you, the pairs in each group. Now, Théophane, the floor is yours.
Yes, let me find my papers first. Thank you, Guillaume. So good afternoon, everybody. I hope nobody is sleepy after such a nice food. You are all awake. Okay. So the session, it's a panel discussion on children access to justice, national practices, and international challenges. So for this, we have 3 panelists, and I'm going to call them Samali Wakule to come forward. Juliet Gachanda and Robert Nanima. So basically what we intend to do in the next 1 hour is to identify barriers to the availability and effectiveness of access to justice for children across jurisdiction. And these 3, the 2 men and the 1 man, the 2 Ugandan and the 1 Kenyan, will help us sort it out. So I'll first let each one of them to introduce themselves because before I start the questions.
All right, thank you very much. My name is Wakoli Samali. I am an Assistant Director of Public Prosecutions, and I work for the Office of the Director of Public Prosecutions of Uganda. In the office, I head the Department of Gender, Children and Sexual Offenses. So all cases involving children are under my docket, and I supervise the whole country. I also appear in all courts, from magistrates to the Supreme Court, and I've been a prosecutor now for 18 years.
Good afternoon. My name is Ruth Juliet Nyambura Gashanja. I am an advocate. I am also a lecturer of the law in Kabrak University, and I am the Child Justice Advisor to the Chief Justice, and a member of the Standing Committee on Administration and Access to Justice for Children. Remember this, I will tell you why it's important.
Good afternoon, ladies and gentlemen. I'm Robert Nanima. I'm a member of the African Committee of Experts on the Rights and Welfare of the Child. I also serve as the Special Rapporteur on children affected by armed conflict. In my previous life, Samali was my boss. So I was with the DPP for 9 years before venturing into academia. So when I'm not with the committee, I'm at the University of the Western Cape in the Department of Criminal Justice and Procedure as an associate professor. Thank you.
Thank you. So let me start with the first question. Yeah. What are the major barriers, including cultural and social norms or challenges, that children in Uganda and Kenya face in accessing justice in cases of sexual exploitation? And what measures have been taken to overcome those barriers? And of course, to Robert, I will ask him to address the same question, but from the African perspective, the African Committee perspective. Thank you. Over to you.
I'll share with you my experiences as a foot soldier, the one who sits in the cases every day. Since yesterday, I've been listening, and quite a number of challenges. It is one thing to talk about access to justice, and it is also another to have the feel of what it is. One is that many of you who are in this room will talk about access to justice, and you are experts in your very own right. But on the day I call you to come to court, you'll develop cold feet. And you'll need a counselor. I have to sit with you, I counsel you before you come to court. So if an adult fears court, place yourself in the position of children. The courtroom environment is very intimidating, and in most of the jurisdictions, it was not made for children, but rather adults. If you look at the witness boxes themselves, the infrastructure, if you're to put a child in that witness box, they will disappear in the witness box. So it's critical that we look at some of those small things before we go to technicalities. What are those small aspects that affect access to justice? We discussed early in the morning about legislation, some laws. Some countries don't have the legislation prohibiting OXEA, but also in most of our jurisdictions, the law places a very high burden on children. The requirement of corroboration on evidence of children, yet we have precedents where a case on sexual assault can be proven without the requirement of corroboration as long as court finds that victim believable. However, when it comes to evidence of children, the law always requires that such evidence has to be corroborated. That in itself is a barrier, because there is nobody who will call a whole clan and tell them, you see now I'm going to abuse so-and-so's child, come and see. You'll never find eyewitnesses for sexual offenses. So you either choose to believe the child or you'll not have that case prosecuted. The other aspect to it is the requirement, therefore, of inquiring into whether this child is possessed with sufficient intelligence to give evidence. I mean, if a child can talk about what happened to them, that in itself is enough. But the law requires that courts must inquire into the level of intelligence before a child testifies. That in itself is affecting access to justice. When we talk about sexual exploitation, and if it happens online, it is across borders. And from the report that we have been doing the study on, it shows that largely the perpetrators are peers, and it happens among fellow youth. Have you sat back as experts to think that maybe these are also victims? Who recruited, who taught those children about sexuality? And are we therefore going for the right perpetrators? Because there is somebody who is an adult grooming and teaching these children to recruit others. So who is inducting children to recruit fellow peers? Those are the people we should focus on. So getting the actual perpetrator is difficult, but then also you have a child who says, but this one is my friend, and she's the one who recruited me into this. But when you look at the two, you have actually two victims and not actually the perpetrator. So from yesterday, our discussions, and what is also clear is that for cases of sexual violence, the perpetrators are very well known to the victims. And that brings in another barrier, because many of the cases will be settled. When we talk about settlement, who is benefiting from the settlement? We don't want to proceed to court. So it has aspects of witness interference and prohibiting people to come and talk to court about what actually happened. If it's a primary caregiver, who is the abuser? How long can we keep this witness or the child in a safe place? And I want to bring those questions such that we can think about them, and then we discuss many of the aspects that will come to it. Also, when we started online sexual exploitation, at that time, Chair, we had largely Facebook and WhatsApp. Right now, we have YouTube, we have Instagram, we have Twitter, and tomorrow, also another program is coming up. Us who are seated in this room, how prepared are we to switch also quickly to the new modes of technology to ensure that there is access to justice for many of the children? Those are a few barriers I am looking at because they are vast, and I know that many of the experts in this room know them, and I would like to stop there.
Thank you.
Thank you. So I will not repeat what she has said, but one of the things I want to admit is that luckily in Kenya, when it comes to adducing of evidence on sexual exploitation cases, corroboration is not required through the Evidence Act. So luckily, yes, for children matters, and for that reason, we are able to at least be able to prosecute some of these cases, but that doesn't mean that we don't have our own barriers. I think one of the first barriers I find from my experience as well working with children and asking this question, maybe it's just the definition of what justice is and what access to justice is for children. What justice is for prosecutors is a conviction, and I think today somebody said that. For the police is an arrest. For the court, it is to actually finish the case. And for the lawyer is to get paid. But for the child, I mean, truly, I'm a lawyer, so, you know. But for the child, really, the aspect of justice is pretty different. And every time I've had a conversation with either the child who is in a remand home or the child who is a victim, they just say they just want to continue with their life. They just really want to move on with their life. If their photos are on social media or whatever, they just want to go on with a normal life. And that makes me question my idea of what justice is and how we apply that for children. And that is why I'm grateful for our Children Act, because the new Children Act, what it does, instead of focusing so much on the systems, it actually makes us, all of us, look at the child and say, what are the needs, what's the welfare of the child? So that's the first problem I see there, or a barrier in terms of access to justice, is what is justice for that child? The other thing, I think, is our broken justice chain. And today, the chief guest, Honorable Charity, spoke about it. The broken justice chain. So this is what I say. I've done a survey in some of our courts in Kenya, actually not courts, but in our systems. So I'll go to the police station and I'll say, how many cases of sexual exploitation have you seen? They will say maybe 15. I will go to the Department of Children's Services. I'll say, how many cases have you seen? This is the same area. They will say they've seen about 5. When you go to court and then you say, how many cases have you seen? They will say about 3. So that tells me that the information is not trickling down. We have the problem yesterday we were discussing was reporting, right? So we're talking about that people do not report. But in the event that they report, how many of those cases go through that system and they actually go to the end? The problem with a broken justice chain also is that every time a child goes through, and I'm speaking in terms of Kenya, every time a child goes through that justice system, they come out a different person. So when they go to report at the Department of Children's Services, they experience re-victimization. They go to the police, then they go to court, and they have to repeat the same story. And as I say, and today I think it was said, at least the prosecution is trying to see how do you adduce, pre-recorded evidence. But this is one of those gaps that we'll have to address as we go along. So the broken justice chain for us is a big problem. We identified it. That standing committee that I talked about, it was one of the things we identified, not only for children who are victims of sexual exploitation, but children across the board, whether they come to us as victims in conflict, children in conflict with the law or children in contact with the law. The other issue I see is evidence, storage and adducing of evidence in court. It's a very big problem. So the child goes, if a victim of sexual exploitation, we have several trainings as well here in Kenya, but still it's not enough. And again, I don't know, I'm wondering what it is that we really need to do, but this is a clear gap. So storage of evidence and then adducing that evidence in court. And finally, so that, because there are many problems, is really when I think about access to justice, I'm thinking about the distance between the child and the courts and the police station and the hospitals and the Department of Children's Services. When we were developing our Children Act, we went around the country, and Jennifer is here. She used to ask children this question: do you know who is the closest to you that you can report to in case of anything other than the teacher? So in terms of the government, the Department of Children's Services or the chief or whatever, and very few children say they know where the Department of Children's Services are. Very few children know the police, where they are standing. The traffic police, everybody knows them. They'll see them walking around. But as to where they can, find help in terms of the Department of Children's Services, for us, that remained a very big problem. And so when we are thinking about access to justice, even from the point of view of the Office of the Chief Justice, we are trying to address these things, the proximity of the courts, the proximity of services as well. Thank you.
Yes. Thank you very much. I start from the perspective that children are in different environments. Children could be in peaceful environments, which on average I think 97% of us come from. Children could be in spaces where there is actual conflict. Children could be in spaces where they're in transition from areas of conflict, or where there is violence as a result of election petitions, where they have been internally displaced. So when we speak about access to justice for children, let's not forget the other 2/3 of the puzzle. Those other 2 parts are often not dealt with, at times not because we don't want to deal with it, but because we don't have sufficient governance systems. They could be controlled by armed groups. They could be controlled by groups that feel that are acting as quasi-governments. So that's a question that I cannot answer now, but let's try to look at the box a little wider. That's one. Then secondly, when you're talking about access to justice from the perspective of the human rights systems, they have some kind of triangle. There should be a law that provides for the human rights system. There should be an institution that is that in human rights system, and it should be putting across jurisprudence in terms of communications that speak to actual guidance to the states in terms of what they can do to improve the space of the child. So in the children's discourse, we have the African Committee of Experts on the Rights and Welfare of the Child. The question is, which barriers do we face? For us to be able to get an issue that deals with children, there has to be some kind of exhaustion of local remedies at some level. So if the institutions are broken at the national level, and a child cannot get any kind of remedy at the national level, it's only then that that child can come. That's if the child is bringing a communication. The other aspect is if the state itself is willing to give us insights on what it's doing to protect children in its territory. If a state is not doing that, we have no ground to give recommendations on what should be done or on what should be improved. We usually approach aspects of engagement from the perspective that we give the state the opportunity to first deal with the problem, and when it has failed, then we can deal with that problem later. So in terms of other barriers, children don't know so much about the committee. First of all, the name itself is a mouthful. Adults also struggle with it. The African Committee of Experts on the Rights and Welfare of the Child. At times it's referred to as the African Commission of Experts, at times African Commission. So it's not only a problem for the adults, it's also a problem for the children. So I think as CSOs, we have a very critical place to play in terms of providing advocacy on what the committee can do, in terms of directing the agenda with the committee. I think this is something that I spoke to yesterday. I'm alive to the fact that ECPAT has observer status with the committee, so it can direct the agenda on sexual exploitation. It has done that. We have a general comment on online sexual exploitation. But a question to the other NGOs in the room, other civil society organizations: have you thought of applying for observer status? Have you been working in your areas for a period of 3 years or more? So until we have a proper justice system at the national level, we'd still have the problems at the continental level. But another barrier from the African perspective, not from the perspective of the community, I would like to look at access to justice, the concept of justice, not only as something that ends in a conviction not only as something that has to be started by an investigation. There are very many other justice systems. We have traditional justice systems. We have formal justice systems, informal justice systems. How do we use those? For instance, we have what they call community-based paralegals in some countries, who serve a very good role in providing information, providing education, providing guidance to people so that they know where to go, when to go when they have a problem. Usually we look at the legal aid triangle and we feel it's a preserve for lawyers when we talk about legal aid. But at times just the legal representation at the top. If it's about legal information, how do we ensure that we have people in the community who can give this information to families? And I think the biggest question, how do we ensure that whatever we're doing in our different spaces can help the life of that child in a specific setting in the community? Thank you very much.
Thank you very much to the three panelists. The second question is, if we take Uganda and Kenya, are the specialized court or legal procedures in place in your countries to handle cases involving child victims of sexual exploitation? But also, and if so, what have been their impact and effectiveness? But also, I think we could also, I would also be interested to hear from you, how would you ensure the protection and well-being of child victims throughout the legal process? You know, are there support services such as counseling or rehabilitation programs available in your countries? But also from the African continental perspective, what do we know, what do we have? Thank you.
Thank you. This is how I'll look at it. We may not be on top of everything, but we are trying. We realized that for cases of children, the sooner they are handled, the better. Because in the normal criminal justice system, and this is not only peculiar to Uganda, in most of the jurisdictions, cases take long in court. However, when it comes to cases involving children, our Children Act requires that cases should be disposed of in a period of 1 year. That is with regard to children who are in conflict with the law. However, victims of crime, their cases tended to take long until now we came up with handling special sessions. These special sessions, we hold cases especially involving children and ensure that cases are fast-tracked, all those involving children. And in handling the cases during special sessions, we have adopted child-friendly mechanisms, because when you're dealing with a child, you're not going to handle them in the same way. We are all professionals, but none of us in our specific professions, maybe apart from the social workers, are taught on how to deal with children. Lawyers are only taught law, but they never teach us on how to interact with children. So, and yet in our practice, we are actually dealing with children, judicial officers, and the rest. So in the special sessions, we have adopted special procedures. If it is a child that is at